Valeriy Ernestovich Drelle against Servis-Terminal LLC in liquidation of the Russian Federation.
Good morning, my lords. My lords, I appear with my learned friends, Dr. Mokal and Miss Johnson for Servis-Terminal, and my learned friends, Mr. Samek and Miss Breslin, appear for Mr. Drelle.
Yes. Now, before we get underway in a substantive manner, can I mention two matters affecting how the appeal is conducted? First of all, a very straightforward one. Tomorrow we will be back in Court 1. We rearranged to sit in here because the air conditioning is a bit better, but there's another case in here tomorrow, so we're back in Court 1 for that. The second thing that we wanted to raise with the parties relates to what I think of as the cross-appeal, but is called the disputed debt issue. That's not a matter that's been dealt with by the Court of Appeal, and our provisional view is that, depending on how the appeal goes, if that is a matter that needs to be addressed, that we would remit that to the Court of Appeal to deal with, rather than us dealing with it here. I say that both to give an opportunity to the parties, if either of you want to try to persuade us to adopt a different approach to that we will make time for that at the outset. But the second reason, of course, is so that if that remains the view, we don't take up time dealing with matters going to that particular issue. So I don't know what your position will be. I don't know what Mr. Samek's position would be on that.
Well, my lords, first may I say thank you very much for choosing the cooler court. It really is much appreciated. As for the second matter, we had anticipated that this question might arise, and the way in which we are intending to run our argument means that Miss Johnson will be dealing with that at the very end. And so, with your lordship's permission, what we will do is we will consider it amongst ourselves, and we will work out how best to assist your lordships, but we understand the point your lordships are making.
Well, it sounds as though you're going to have enough to say on the appeal, certainly up to the short adjournment. So could I suggest that we get underway now, not take up any more time debating this, but if the parties can put their heads together over the short adjournment and tell us what their position is when we come back in after that.
Certainly. Well, my lords, I hope against that background it will be convenient for me to explain to your lordships how we intend to divide our time, our manpower. I am going to deal with grounds 1, 3 and 4, and I will also deal with the position under the 1933 Act. Dr. Mokal is going to deal with ground 2, which is Article 13 of the CBIR, and my learned friend Miss Johnson is going to deal with the disputed debt issue to the extent that we deal with it before your lordships.
Yes.
In addressing your lordships on my part of the appeal, I intend to follow the following structure. First, core propositions. Second, the obligation principle and enforceable debts. Third, Rubin. Fourth, the revenue and penalty rules. Foreign exercise of sovereign power. Fifth, debt and remedy. Sixth, execution of a judgment and enforcement of a claim. And finally, seventh, the 1933 Act. May I start, my lords, with the core propositions? At the heart of our case is the proposition that a final foreign judgment ordering a debtor to pay a definite sum of money to a creditor gives rise to a debt within the meaning of section 2672B of the Insolvency Act, on which a bankruptcy petition can be presented. The central proposition relied on by Mr. Drelle is that until an English order for payment is made, the sum awarded by a foreign court is not a debt owed or payable. That is said to be because judicial adjudication is an exercise of state sovereignty, and state sovereignty ends at the border. To treat a debt arising under a foreign judgment as a debt in this jurisdiction would amount to treating the foreign court as having sovereign authority here. The foreign judgment is therefore completely unenforceable in this jurisdiction. It is said that this has been settled law for over 150 years. In our submission, the final judgment of a competent foreign court, unless impeached, is conclusive in English law as to the matters it determines. A debtor ordered to pay a definite sum is under an enforceable obligation to pay that sum. The obligation resulting on the debtor to pay the creditor a definite sum gives rise to a debt, including for Insolvency Act purposes. As to the exercise of sovereign power, determining a dispute between two non-state parties making personal claims is not the exercise of sovereign power of a type that makes it unenforceable. In the case of revenue and penal liabilities, it is a liability imposed by and owed to the state as sovereign. A court determining individual rights is not imposing a liability owed to the state, let alone as sovereign. Servis-Terminal can enforce the foreign judgment debt. The obligation to pay a debt or a definite sum of money ordered under the foreign judgment can be enforced by claim or counterclaim, and that is Dicey Rule 46.1. And if I may take your lordships to Rule 46.1, is it convenient if I just give your lordships the page reference?
It is,
yes. 1856, 1856. This is Dicey Rule 46.1. And if your lordships look at 46.1, it's picking it up in the second line, a foreign judgment in personam given by the court of a foreign country with jurisdiction to give that judgment, and then it sets out those principles, which is not impeachable, may be enforced by a claim or counterclaim for the amount due under it if the judgment is A, for a debt or definite sum of money, and it there excludes taxes and charges of the like nature or in respect of a final penalty, and B is final and conclusive. Servis-Terminal's judgment debt satisfies the two conditions in Rule 46.1. It is a judgment for a debt or definite sum of money that is final and conclusive. Servis-Terminal can enforce by a claim, for the amount due under the Russian judgment. If Servis-Terminal can enforce that legal right to be paid a debt or definite sum by a claim, Servis-Terminal can petition on the debt, unless there is a bona fide dispute that the Russian judgment is impeachable. The requirement under Section 267 of the Insolvency Act is that the debt must be for a liquidated sum payable to the petitioning creditor immediately. An enforceable claim for immediate payment of a debt or definite sum of money satisfies that test. There is no separate or additional obligation to seek recognition of the judgment. As to my learned friend's submission that recognition is necessary as a matter of substance in order for the obligation to arise, there is no additional need for a judgment to be recognised in order for the obligation to arise. The obligation already exists. My learned friends therefore argue that the foreign judgment creditor's right to enforce the order for a debt or defined sum is exclusive to Part 7 proceedings, and the legal right to be paid the debt due and to enforce that sum can only exist in a Part 7 claim. They submit that it cannot also be a debt in bankruptcy proceedings. However, if there is a right to payment of an amount and that right can be enforced by claim, the right holder has a debt claim and is a creditor. What is enforced in a Part 7 claim is the debt arising under the foreign judgment. That same debt is what is enforced by the bankruptcy petition, and that may be proved in a bankruptcy. And that raises the question, why seek recognition by way of a Part 7 claim? The first answer is that the judgment might go wider than a judgment for a debt or definite sum of money. It is only in respect of claims for a debt or definite sum of money that a foreign judgment creditor can enforce payment of the sum due. A judgment that grants relief that goes beyond an order for payment of an amount due for a debt or a definite sum can only be enforced in a Part 7 claim for the wider relief granted by the foreign court. There will also be circumstances in which the foreign creditor needs an English judgment. Recognition at common law and registration, which we will look at in due course, are processes available for creditors who need to have an English judgment. The creditor will either seek recognition in a Part 7 action, which gives them an English judgment, or, if it's a registrable judgment, registration, by which the foreign judgment is treated as if it was an English judgment. Creditors need English judgments in order to directly enforce the English judgment. For example, under the processes identified in CPD 70 and prior to the 1986 Act, which I will show your lordships, the old bankruptcy system. An English judgment was required for service of a bankruptcy notice.
Sorry,
However,
what was the date you mentioned just there?
Prior to
the Insolvency Act of 1986. Yes, it's under the Bankruptcy Act of 1914. And just looking ahead.
I mean, the simple reason why, in the ordinary case, you want to get your judgment recognised or registered is because you want to avail yourself of the English means of execution.
Precisely.
You want to get your whole debt paid by some means of execution rather than queue up with everybody else in a bankruptcy process.
Yes, my lord. No, it's precisely right.
Yeah.
It's precisely right. And the only reason why I also mentioned the previous position that you needed a judgment in order to serve a bankruptcy notice is that was the position in relation to the McGreevy case that we'll look at.
Yeah.
Turning to Servis-Terminal being able to prove, as to proof, my learned friends argue that the foreign judgment holder cannot petition because that would be the enforcement in this jurisdiction of foreign exercises of foreign power. And there are examples throughout, but paragraph 31 is the one I've written down. However, at the same time, they argue that a foreign judgment holder can prove for the debt in the bankruptcy. The problem for my learned friends is that if the creditor cannot petition because the obligation arose by the exercise of foreign sovereign power, the creditor should not be able to prove either. And if a debt will not be, and that was the decision in Government of India.
You could prove for a contingent debt, couldn't you?
Yes, but the point of this point is that if it's an exercise of sovereign power, as for example in the revenue debts, then Government of India and Taylor says you can't prove either.
No.
And so if the obligation cannot give rise to a petitionable debt because it's an exercise of sovereign power, it cannot give rise to a provable debt. And as I've said, that was Government of India and Taylor, since the tax debt was not enforceable, it was not provable either. And if Servis-Terminal's debt is provable, the exercise of sovereign power cannot be the reason why there is no debt for the purposes of a petition. And that inconsistency runs through my learned friend's case. In paragraph 13, he says that a foreign judgment does not itself have legal effect in this jurisdiction other than through Dicey Rules 45 and 46. But in 79.1, he says it is undoubtedly the case that a foreign judgment does give rise to a cause of action, common law action on the judgment. As your lordships will appreciate, a cause of action is a legal right with legal force. It is this cause of action which carries with it the right to submit a proof of debt in the bankruptcy. And in 79.1, my learned friends accept that the trustee in bankruptcy can admit a claim. That is giving legal effect to the debt arising under the foreign judgment. It is not simply using that claim as a shield rather than a sword. Those were my 4 propositions.
Yes.
Can I move on to the obligation to pay? A foreign money judgment creates an obligation on the debtor to pay. It is an obligation to pay a liquidated sum immediately. There is no dispute that the Russian judgment creates an obligation on Mr Drelle in Russia. The judgment of the Arbitrage Court of Yaroslavl followed a 14-month process in which there were 10 hearings, as well as written submissions. Mr Drelle participated throughout. Mr Drelle was found liable for breaching his duties to Servis-Terminal in lending 2 billion rubles to Fort Staten, the borrower. The judgment was for 2 billion rubles. Claims for loss of profits and against the shareholders and the CFO were dismissed. Mr Drelle appealed to a 3-person panel of the Court of Appeal. Having conducted a full review, that court dismissed the appeal. There was then an appeal to the Court de Cassation, and leave to appeal to the Supreme Court was then refused. So that, my lords, is the history. The obligation to pay was for a debt or definite amount of 2 billion rubles. In the present case, the bankruptcy petition is based upon a final judgment, and the only question is whether that judgment is impeachable as a matter of English law. So turning to ground 1, it is uncontroversial that an unimpeachable final foreign judgment given by a court of competent jurisdiction is conclusive as to the matters of fact and law adjudicated upon. The Russian judgment decided that Mr Drelle is indebted to Servis-Terminal for the sum of 2 billion rubles. And if I could then take your lordships to section 267, which your lordships will find at page 445. This is section 267 of the Insolvency Act, my lords, and 267 deals with the grounds of a creditor's petition. A creditor's petition must be in respect of one or more debts owed by the debtor and the petitioning creditor, or each of them and others. And then subsection 2 gives you the conditions of the debt. So a creditor's petition may be presented to the court in respect of a debt only if, at the time the petition is presented, and the first condition is that it must be equal or to or exceed the bankruptcy level. And then in B, the debt is for a liquidated sum payable to the petitioning creditor either immediately or at some certain future time, and is unsecured. And then you have C and D, which deal with the debtor appearing either to be unable to pay or to have no reasonable prospect of being able to pay. And there's no outstanding application to set aside a statutory demand. And so that your lordships are aware, on 447 you'll find 268, and 268 is the service of a statutory demand. And that gives rise to the proof of inability to pay. And just 2 quick points. A debt for a liquidated sum has to be a pre-ascertained liability. We get that from McGuinness and Norwich and Peterborough Building Society, which for your lordship's notes is in Authorities C28, page 784. I don't intend to take your lordships to it. And the second comes from Government of India and Taylor. It has to be an obligation which is legally enforceable in an English court. So I turn then...
Can we just have a bundle reference?
For Government of India and Taylor, I'm sorry, I'm going to take your lordships to it.
We'll wait.
In detail. Well, not too much detail, but I will take your lordships. I apologise.
It's all right.
Turning to the obligation principle, where the judgment of a foreign court imposes a duty to pay a sum certain, there is in English law an obligation to pay. In some circumstances, the English courts will enforce the obligation to pay the sum due. And my lords, if we could go to Owens and Bracco, which your lordships will find at page 859. Which is in tab 33. And my lord, the principle is summarised by Lord Bridge at page 484b, which is on page 900 in your lordship's electronic bundle. And I just want to pick it up at letter B, where Lord Bridge says, a foreign judgment given by a court of competent jurisdiction over the defendant is treated by the common law as imposing a legal obligation on the judgment debtor, which will be enforced in an action on the judgment by an English court, in which the defendant will not be permitted to reopen issues of either fact or law which have been decided against him by the foreign court. That is a description of the principle. It is a principle that has been recognised by the English courts since 1705. And I want to show your lordships 3 of the authorities, if I may. The first is Russell and Smythe, which is in 1842, and that is at page 1130 of the electronic bundle. And if your lordships just turn, if you would, to 1133, which is the beginning of Lord Abinger's judgment, where he says, 3 lines down, the question arises in Scotland, and the decree of the Court of Session creates a duty in the party to pay a debt and does not give rise to the question of jurisdiction. And then picking it up 3 lines from the bottom, foreign judgments are enforced in these courts because the parties liable are bound by a duty to satisfy them. And then if I could pick up Baron Park, which is on page 1134, and it's about 10 lines down, where he says, I agree with Lord Abinger. I agree with Lord Abinger in thinking that an action will lie for the recovery of costs awarded by a foreign court of competent jurisdiction, where the court of a foreign country imposes a duty to pay a sum certain there arises an obligation to pay which may be enforced in this country. And from that, my lords, your lordships can see the beginnings or the source of Rule 46.1 that we see in Dicey. And Baron Part refers to a sum certain and the foreign court imposing a duty to pay, from which, of course, the question whether the judgment is final comes. The second authority I wish to look at is Goddard and Gray, which your lordships will find at page 584.
Sorry, page.
Sorry?
Page.
Page 584, my
Thank you.
Sorry, I apologise. Unfortunately, I still use paper, which is becoming increasingly...
You're in very good company in your row, Mr. Phillips, but not in our row.
No, I understand, my lords. But anyway, it's page 584, Goddard and Gray. Yes. And if one starts at 593, your lordships will see that Mr. Justice Blackburn's judgment is a judgment, in fact, of Justices Blackburn and Miller. It starts on internal 147, which is 592, but picking it up at 148, where he explains this. Still, the fact remains that we can see on the face of the proceedings that the foreign tribunal has made a mistake on the construction of an English contract, which is a question of English law. So what you had was a judgment from the French court, and the English court could see that the French courts had made a mistake in relation to the French judgment. And picking it up in the third...
Sorry, in respect of the English contract, I think you meant.
It was an English contract. Yes, I'm sorry.
You said they made a mistake in respect to the French judgment. I think...
Oh, yes, I'm sorry, I misspoke.
Yeah.
I'm sorry. And if one picks up the next full paragraph, the question raised by the plea is whether this is a bar to the action brought in England to enforce that judgment, and we are all of opinion that it is not, and the plaintiff is entitled to judgment. And then, if I can pick up in the next paragraph, it's not an admitted principle of the law of nations that a state is bound to enforce within its territories the judgment of a foreign tribunal. And then 3 lines down, but in England and in those states which are governed by the common law, such judgments are enforced not by virtue of any treaty or by virtue of any statute, but upon the principle stated by Baron Park, that where a court of competent jurisdiction has adjudicated a certain sum to be due from one person to another, a legal obligation arises to pay that sum, on which an action of debt to enforce the judgment may be maintained. It's in this way that the judgments of foreign and colonial courts are enforced. So your lordships again see it's an obligation to pay the sum adjudged. The third case is at 1135, which is Shibsby and Westernholtz. Sorry. C45. Yes, it starts at 11:35.
This was the same day. This judgment was given the same day as Goddard and Gray. Is that correct?
I had not spotted that, my lord. I had not spotted that. Can someone just check that? Yes, it is. That is confirmed. So if your lordships can just look at the head note, judgment of a foreign court obtained in default of appearance against defendant cannot be enforced in English court where the defendant was not subject or resident. For there existed nothing imposing on the defendant a duty to obey the judgment. And if I can pick it up at 11:39, which is internal 159, and I take your Lordship's point, because I hadn't picked up the saying that in the two-sentence paragraph, the one-sentence paragraph, it's unnecessary to repeat again what we've already said in Goddard and Gray. The true principle on which the judgments of foreign tribunals are enforced in England is that stated by Park in Russell and Smythe and again repeated in Williams and Jones, and the judgment of a court of competent jurisdiction over the defendant imposes a duty or obligation on the defendant to pay the sum for which the judgment is given and which the courts in this country are bound to enforce. And again, your Lordship see the reference to the debtor being bound to pay the sum for which the judgment is given. And if the debtor is obliged to pay the foreign judgment, the English court is bound to enforce the judgment. And for your Lordship's note, these passages were cited with approval in Adams and Cape Industries, which is in tab C9 at 498.
I mean, it looks as though these were intended to be a composite statement of the law. I mean, it's interesting that at the top of page 1139, effectively, Miss Justice Blackburn and Mr Justice Mellor have bound in Miss Justice Lush, who was not a party to the discussions in Goddard and Gray, and got him to agree it. So this is the position that's being definitively stated at this stage, at that level.
Absolutely, and my Lord, your Lordships will see that that's then what becomes 46.1.
Yes.
That's what's summarised. And in relation to 46.1, so as I've said, that summarises the circumstances in which the obligation may be enforced. And it is a claimant with a final judgment for a debt or definite sum, and they can enforce that by claim. That's what you can see. And there are a number of illustrations in Dicey, and I just wanted to show your Lordships one, if I may, which is a case called Rowland and Fisher, which is in, it's at page 1893, authorities 72. And the reason why I want to show this to your Lordships is that this was a claim for personal injury. And if I can start with the holding in the headnote, so that where it says the portion of the judgment awarding damages to the injured person is not within the rule of international law which prohibits courts of justice from executing the penal judgments of a foreign court but may be enforced by action in this country. And the reason why I'm drawing this to your Lordship's attention is that what happened was that the plaintiff was injured by an accident in France, and that resulted in a criminal process and also civil law damages. And there was a claim, and the claim, of course, is damages for personal injury. And a claim for damages for personal injury, of course, does not become a claim for a definite sum until the judgment is given. And the plaintiff relied on the French judgment awarding damages for injury, and as I've said to your Lordships, that same judgment imposed imprisonment and a fine on the defendant. And the question was whether the civil part of the judgment was the exercise of French sovereignty. That question was raised, and the defendant argued that the English court lacked jurisdiction under the penalty rule since damages had been awarded by a criminal tribunal as the result of a conviction for a crime. And my Lords, if we could go to internal page 98, which is 1898, and we see that Mr Justice Hamilton, and it's, I think it's about 11 lines down, where he says, a proceeding in order to come within the scope of the rule must be in the nature of a suit in favour of the state whose law has been infringed. I have therefore to inquire, first of all, whether this judgment, insofar as it concerns the present plaintiff, is one for the satisfaction of a private wrong or for the punishment of an infraction of public law, and secondly, whether if it be as regards him only for the satisfaction of a private wrong, it's one that can be separated from the rest of the judgment, so that he may sue upon the judgment in spite of the fact that a considerable part of it relates to purely criminal proceedings. And then over the page 99, which is 1899, it says, "It seems to me that there is no doubt that the public prosecution and private suit are two quite separate and distinct proceedings, although they are for purposes of procedure combined in one. The judgment for the 15,000 francs is not in any respect a judgment or proceeding in favour of the state whose law has been infringed. It is a judgment in what is substantially a civil suit for the compensation of a person who has sustained a private wrong." And so, my lords, the plaintiff obtained a judgment for the equivalent of 15,000 French francs for damages for personal injury. And the judgment was for the debt obligation that was created by the French judgment. And my lords, if the giving of judgment by a foreign court is itself the exercise of sovereign power of the type that makes the judgment unenforceable, both parts of this judgment would have been unenforceable. However, the civil part was enforceable by claim. The position is that a creditor with a final judgment for a definite sum, which is where we were here, can enforce by claim because they are enforcing the debt obligation, and it must follow that they can petition on the same debt. In each case, the debt is being enforced by the English court. And we say that this is all that is required for us to make our case. Having said that, the Court of Appeal gave additional reasons, and I should now turn to the 3 points that we make about those reasons under ground one.
Has Rawlin and Fisher been, as it were, approved in any higher court?
The ruling round, I haven't found, it's an illustration.
Yes, I can see it's an illustration.
And that's where I got it from.
My question really is just whether it's been blessed at a higher level.
Dr. Mokel's going to check.
All right, thank you.
I hadn't myself found anything.
But it's one of the illustrations given in Dicey's, I think.
It is one of the illustrations given in Dicey, and that's where I got it from.
Yep.
And it's an illustration to Rule 46.1, points of doubt.
Yes.
So the 3 points that we make about the Court of Appeal's judgment, I need to deal with Rubin, the revenue rule and the penalty rule, and then the confusion between debt and remedy. So if I could start, my lords, with Rubin, and you will find Rubin at page 1115. And if I could start at paragraph 5, this is Lord Collins' judgment, and as your lordships know, Lord Walker and Lord Sumption both agreed. But I want to start with paragraph 5,
Page.
Where he says...
Page.
Oh, I'm sorry.
Oh, I've got it.
1121.
Yeah.
I'm so sorry. Yeah. He says, it's been necessary to emphasise that the judgments in all 3 matters were in default of appearance, because if the judgment debtors had appeared and defended the proceedings in the foreign courts, the issues on these appeals would not have arisen. The reason is that the judgments would have been enforceable on the basis of the defendant's submission to the jurisdiction of the foreign court. And of course, the reasoning is if you submit to the jurisdiction, then you agree with whatever the orders made by the foreign court may be. Enforcement would have been at common law, or in the UKSC case under the common law under the 1933 Act. But that's the starting point. And of course, it is because the foreign court would have been a competent court, judgments would have been enforceable by claim. Then if we can go on to 9, and my lords, we need to read the whole paragraph, because Lord Collins starts by saying the theoretical basis for the enforcement of foreign judgments at common law is that they are enforced on the basis of a principle that where a court of competent jurisdiction has adjudicated a certain sum to be due from one person to another, a legal obligation arises to pay that sum, on which an action of debt to enforce the judgment may be maintained. And he then refers to Williams and Jones, Adams and Cape, Owens.
Sorry, which page?
1122.
Right.
I'm sorry, it's a real fault.
So I've just spotted that there seems to be a problem with the copy of Rubin in the bundle. It leaps from internal page 256 on 1124 to
Yes.
page 271.
Yes, my lords, that is because we understood that we should just be putting into your lordship's bundle the sections
Oh, okay.
we're relying upon. But I mean, of course, if your lordships wish to have the whole thing, we will.
We can easily get it.
All right.
Well,
Right. Anyway,
yes.
you're on 1122.
I'm on 1122, my lord.
Yes.
And it's paragraph 9,
Yes.
and I just got to the part where he described just above a legal obligation arises to pay that sum on which an action for a debt to enforce the judgment may be maintained, refers to the cases you can see. And then he says, as Mr Justice Blackburn said in Goddard and Gray, this was based on the mode of pleading an action on a foreign judgment in debt, and not merely as evidence of the obligation to pay the underlying liability. So there was the debate about whether it was just evidence or whether it was an obligation, whether you could plead an action on the foreign judgment debt. But this is a purely theoretical and historical basis for the enforcement of foreign judgments at common law. It does not apply to enforcement under statute, which of course we will look at, and makes no practical difference to the analysis, nor in my judgment, to the issues on this appeal.
At this stage, we're still trying to remind ourselves what were the issues on these appeals, because there's a great bit of debate, particularly with your opponent, about what this sentence means.
Yes. Well, it doesn't make any difference to the issues on these appeals, but what you had is you had two different, because there were two cases, you had two different insolvency findings in foreign jurisdictions, and then there was the question of whether or not those insolvency judgments could be enforced in this country. And in both cases, the defendants had not submitted to the jurisdiction and were not subject to the jurisdictions of the foreign courts. And questions arose as to whether or not Cambridge Gas was right in giving a broader effect in the context of insolvency, and that was held not to be the case, and also whether or not they fell within the 426 jurisdiction in relation to the Australian case. So that was a real snapshot of a complicated case. And if your lordships need further assistance, I will, of course, give it to you. But in relation to the point I'm just dealing with on paragraph 9, as your lordships see, Lord Collins identified the theoretical basis for the enforcement of foreign judgments, and he said, being that they are enforced on the basis of a principle that where a court of competent jurisdiction has adjudicated a certain sum to be due from one person to another, a legal obligation arises to pay that sum, on which an action of debt to enforce the judgment may be maintained, which is a statement consistent with the statements that your lordships have seen, and he referred to Williams and Jones, Goddard and Gray, and Adams and Cape, and Owens and Bracco, describing the underlying basis as a purely theoretical basis for the enforcement of judgments of common law is how he explained the underlying basis. You cannot read into that, and this is the only important point for present purposes, you cannot read into that in our submission that he disagreed with that as the basis. And if he had disagreed with that as the basis, he would have said so, and he would have explained why. So in our submission, if it is suggested that Lord Collins was cutting down or undermining the underlying obligation principle, in our submission, he was not. And if you can then look at paragraph 10, where he concludes...
He doesn't suggest any other basis to explain them.
No, he doesn't, my lord.
He's just drawing a distinction between the common law and the statute.
Yeah, well, yes, that's our reading, my lord. Absolutely. Paragraph...
The case was all about statute, wasn't it? Common law was part of the background, but it wasn't what the issues are really about.
No, it wasn't. One of the points is that that's why he says it doesn't, in his judgment, make doesn't make any difference to the issues on the appeal.
I mean, if you had just read that observation in the abstract, purely theoretical and historical basis that makes no practical difference to the analysis, you might think he's pouring quite a lot of cold water on it.
No, I understand. But if he was doing that, in our respectful submission, he would have explained why.
Would have explained what the correct theoretical basis was, one would have thought.
Yes, precisely, my lords. And it's one of those occasions where one can look at this and then try and read a lot more into it. But there is no indication that he didn't agree, and one can't... our submission is you can't read any more into it than he is explaining the basis.
I mean, I also wonder whether you need to read it in the context of paragraph 5, where he explains that someone that accepts, submits to the jurisdiction of the foreign courts, that's the foundation for the obligation that they then have to abide by the judgment. No submission, no obligation. So when one comes on to 9 and 10, I mean, it might be said, well, you have to read those in the context of that fundamental point that he's made at paragraph 5.
Yes, my lord, and that's one of the reasons why I started there.
Yeah.
And in paragraph 10, what he says is, if the judgments in issue on the appeal are regarded as judgments in personam within the Dicey rule, then they will only be enforced in England if the judgment debtors were present, resident, or submitted. So that wraps it up, as it were, on that point.
I mean, effectively, it kicks the common law into the touchline so far as concerns any basis for the enforcement that was being sought in that case.
Mm.
Yes.
Yeah.
No, absolutely, my lords. And my lords,
But also it's significant that he's looking for, he says that you have to look for a foundation of the obligation on the person subject to the judgment, which you find in their presence in the country or submission to the jurisdiction.
yes,
I mean,
and that's what
seems
makes...
to be the foundation for the theory.
Yes, my lord, and that's what makes it a competent court. And and from it being a competent court, the obligation to
I mean, competent just means competent to
With
bind the
jurisdiction.
parties before it
Yes.
by their judgment.
Yes. And my lord, I can tell you, in answer to my Lord Briggs' question, that Rowling has been approved by the Court of Appeal. And we will send your lordships the case reference, but it was approved in United States Securities and Exchange against Manterfield, and the reference is 2009 EWCA Civ 27. Is that at paragraph? At paragraph 24. My lords, we will, of course, provide your lordships with that judgment. So, my lords, that was Rubin, and the next point I need to deal with is the revenue rule and the penalty rule. So, while a foreign judgment creditor has a claim enforceable in an English court, neither a foreign revenue claimant nor a foreign penalty claimant has any such claim. That is pursuant to the revenue rule and the penalty rule. imposing taxes or penalties is an exercise of sovereign power. It is the state imposing a liability that is owed to the state as sovereign. The Court of Appeal, with respect, conflated the position of a creditor with an unimpeachable judgment on an individual claim with the position of a claim by an emanation of state under a foreign revenue law or foreign penal law. It is the nature of the claim that determines whether the claim is enforceable, and not simply that it is a foreign court pronouncing the judgment.
And as I understand it, the effect of the rule, if it applies, is that you simply cannot treat the foreign judgment as a cause of action on which you can get an English judgment.
Absolutely correct, my lord.
Yeah.
On the basis of jurisdiction. On the basis of jurisdiction.
Yes, my lord. Yes. No, absolutely. And you couldn't prove on it, which are come to in Government of India and Taylor. If I may take your lordships to the Court of Appeal's judgment, which is at 131. I just wanted to take your lordships on page 131. I wanted to start with paragraph 13. In paragraph 13, it quotes from Dicey and Morris, and it quotes from Rule 20, the Court of Appeal quoted at the end of paragraph 13, quoting the rule that English courts have no jurisdiction to entertain an action for the enforcement either directly or indirectly of a penal revenue or other public law of a foreign state. So the Court of Appeal started by recognising that the revenue and penal rules apply to enforcement of penal revenue law of foreign states. Then if we can go forward, if I may, to paragraph 55, which is on page 148, in the middle of the paragraph, sorry, a foreign tax, where's this? Oh, sorry, so sorry. Yes, in the middle of the paragraph, a foreign tax will not give rise to such a debt, and then no more will an unrecognised foreign judgment, which similarly involves an exercise of sovereign power. So your lordships can see the reasoning of the Court of Appeal. The first sentence refers to the foreign tax. With respect, the second sentence is a non sequitur. That assumes that any unrecognised foreign judgment involves the exercise of sovereign power of a type which stops the obligation giving rise to a debt. A tax obligation, as your lordships know, arises as a result of the state imposing a tax liability. By contrast, a judgment adjudicating a right held by an individual is adjudicating a private right and gives rise to a debt. The only exercise of sovereign power in this context is the judicial determination of the claim. If that was an exercise of sovereign power of a type that stops the obligation giving rise to a debt, then every foreign judgment would be the exercise of foreign sovereign power.
Well, you could never sue on the foreign judgment.
You'd never be able to sue on a foreign judgment. What your lordships have seen from the obligation principle is that it demonstrates an unrecognised foreign judgment is enforceable by claim in certain circumstances, while a foreign court giving judgment is an exercise of sovereign power, adjudicating individual rights can give rise to a debt. And if my learned friends are right, then several decisions must be wrong. For example, Rowland and Fisher, which distinguished the penal and the damages elements of the judgment. And the conflation of the position of a claimant under the revenue rule and the penalty rule with the position of a creditor pursuant to an unrecognised, unimpeachable judgment can be seen through a series of paragraphs in the Court of Appeal's judgment.
I'm not
quite sure why you're singling out Rowland and Fisher. Wouldn't it mean all the...
All. My Lord,
Yes,
it's one of those occasions where one finds an illustration, thinks it's jolly useful, and then refers to it too much. My juniors have been telling me off about doing that, but your Lordship is absolutely right.
All right, sorry, I just wanted to...
No, it's just one example of, on the face of it, every foreign judgment.
And the Court of Appeal doesn't focus at all on the final words of Dicey Rule 20, which refers to or other public law.
Yes. No, we don't, my Lord.
I suppose one could read that sentence as not being about whether it gives rise to an obligation on which you could sue for an English judgment, but only about whether it gives rise to a bankruptcy debt, or a debt within the meaning of section 2671. It's all very well plucking one sentence out of context. One has to read it in the context of the whole of paragraph 55.
I'm going to show your Lordship all of the sentences from which I would respectfully submit it's quite clear what the Court of Appeal meant in this. So if I could turn to paragraphs 42 to 43. Where your Lordships will see that the Justice Newing says the revenue law has a similar root. Professor Briggs referred to it as a particular manifestation of more fundamental rule. The assertion or exercise of sovereign right of sovereign state will not be enforced. And then he refers to solo, which I refer to as scatter and solo, which I'll come back to. And of course, Lordships are familiar with that. Enforcement of a claim for taxes is but an extension of the sovereign power which imposes taxes and an assertion of sovereign authority by one state within the territory of the other, as distinct from a patrimonial claim on a foreign sovereign contrary to all concepts of independent sovereignty. And then in 43, the significance of this for present purposes lies in the fact that there can, I think, be no doubt that the revenue rule precludes presentation of a bankruptcy petition in respect of a foreign tax liability, and that I did not demur from that statement. And then at the bottom sentence, where he picks up, that tends to support the contention that an unrecognised foreign judgment which has no direct operation because it arises from an exercise of sovereign power is likewise not to be seen as giving rise to a debt capable of founding bankruptcy proceedings. So, breaking that down, your Lordship will see that Lord Justice Newey refers to the revenue rule being an assertion or exercise of the sovereign right of a foreign state. He then refers to Lord Lloyd Jones in Solo Partners, enforcement of a claim for taxes is but an extension of the sovereign power. He goes on to explain that the revenue rule precludes presentation of a bankruptcy petition, and then one gets the final sentence that we just looked at, where he says that tends to support the contention that an unrecognised foreign judgment which has no direct operation because it arises from an exercise of sovereign power is likewise not to be seen as giving rise to a debt capable of founding bankruptcy proceedings. And again, with respect, it's a non sequitur. The reason is said to be because it arises from the exercise of sovereign power, but whilst, as your Lordships I think have the point, whilst raising revenue or imposing penalties are an exercise of sovereign power, of a type that means tax or penal obligations cannot give rise to a debt, adjudicating rights between individuals is not. So if I can then, there are just a couple more paragraphs, but I think for completeness I should just take your Lordship through them. If one goes to page 151 to paragraph 65, the first sentence, where he says that conclusion is entirely consistent with the common law approach to the treatment of foreign revenue debts in English insolvency.
Hold on.
And he then goes on.
Where are we reading from?
65. 151, my Lord, paragraph 65. It was just the first.
That starts with that conclusion, so we've got to start with 64.
Certainly, my Lords, perhaps if you just posture, I consider the same way as a person who relies upon a foreign judgment cannot invoke the individual enforcement mechanism in English court for his own benefit unless and until he obtains an English judgment or registers the foreign judgment or has some other basis under a statute or treaty that permits its enforcement, so also such a person should not be able to involve collective enforcement mechanisms, bankruptcy and winding up, unless and until he obtains an English judgment or registers a judgment or has some other basis under a statute or treaty permitting enforcement. That conclusion is entirely consistent with the common law approach to the treatment of foreign revenue debts, and he then refers to Government of India, which I'll come to shortly. So Lord Justice Newey says an individual being unable to invoke individual enforcement mechanisms is entirely consistent with the revenue rule. And again, that conflates with respect the position of a state or its assignee seeking to enforce a revenue claim with the position of an individual judgment creditor pursuing a claim that any individual might hold and pursue. And it isn't entirely consistent with respect, because the one pursuing a revenue claim is the exercise of state power, and pursuing a claim that any individual may hold and pursue is not. So the last of the paragraphs is 69, where in paragraph 68, my lords, your lordships will see that there was, with reference to Government of India and Taylor, and it's really the last few lines, in the same way as the word liabilities in 302 was given a qualified meaning in Government of India, so as to accord with the principles of independent territorial sovereignty of the state, so must the word debt in 267 be given a similarly qualified meaning. Indeed, in argument, Mr. Phillips did not dispute that as a matter of general principle, a foreign tax liability could not be regarded as a debt upon which a bankruptcy petition could be based. By parity of reasoning, I consider that the same must apply to an unregistered judgment. So your lordships concede, by parity of reasoning, the principle that foreign tax liability couldn't be regarded as a debt, that, to quote, must apply to an unregistered judgment of a foreign court. And again, with respect, my lords, it's a non sequitur. And I think the lordships have the reasoning, so I won't go over it again. Now, the scope of the revenue and penalty rules can be seen from the authorities, and there are two that I was just going to refer to. The first is Government of India and Taylor, and the second is, as I call it, scatter and solo, and I appreciate I'm not getting that 100% right.
Not sure any of us are fully confident about getting that one right.
Danish tax case, I think.
I'm so grateful.
Well, Dockery and I have practical experience of trying to get the pronunciation right.
Yes, well, starting with Government of India and Taylor, which your lordships will find at page 622. And if I may go straight to page 634, this is where Viscount Simon's judgment starts. And on 634, which is internal 503, Viscount Simmons approved a statement of Mr. Justice Rolat in King of Hellenes, where he says, "It is perfectly elementary that a foreign government cannot come here, nor will the courts of other countries allow our government to go there and sue a person found in that jurisdiction for taxes levied, and which he is declared to be liable to the country to which he belongs." So it's a foreign government coming here, the taxpayer being sued for taxes levied by the foreign government, which of course is the state imposing an obligation owed to it as sovereign. And then on page 638, which is internal 507, Viscount Simmons approves a statement from Dicey, which you can pick up. It's actually 10 lines down, I think. He says, "Essential characteristic, in short, of a penal action is that it should be an action on behalf of the government or the community and not an action for remedying a wrong done to an individual." And with that, my lords, is an important distinction. On the one hand, an action on behalf of a government or the community. on the other hand, an action for remedying a wrong done to an individual, which is not an exercise of foreign sovereignty of a type that makes the judgment unenforceable because it falls within the revenue law. And for completeness, Lord Keith...
Can I check? The Government of India was directly concerned with the revenue rule, is that right?
Yes, my lord.
There's this comment where reference has been made to the penalty rule as well.
Yes, my lord. And what was held was that the Government of India could not prove for the tax liabilities in the insolvency.
Yep.
Lord Keith at 641, which is internal 510, where 11 lines down he just says, in no circumstances will the courts directly or indirectly enforce the revenue laws of another country. Which brings us to the Danish case, which the Lords will find at 1154.
I think it's usually referred to as SCAT. It's a shorthand. SCAT.
SCAT. Thank you, my lord. Thank you. Of course, I appreciate that my lords, Lord Briggs and Hamlin, sat on this particular case. But the position in this case is that the Danish National Tax Authority sued to recover tax refunds that had been wrongly paid out. It did not seek to recover tax either directly or indirectly. And if I could start at paragraph, there are just a couple of paragraphs, 36, which should be on 1172 in your lordship's bundle. And in paragraph 6, I just wanted to pick up the third line. It says, the revenue rule only applies to proceedings in which there is an unsatisfied demand for tax, which foreign tax authorities seek directly or indirectly to recover. In my view, the statement of principle by Lord Mackay cited above forms part of the ratio of the decision in Williams and Humbert. It is an essential step in the reasoning that supports the decision. In any event, it is consistent with what I consider to be the rationale of the revenue rule. If there is no claim, directly or indirectly, to recover tax which is due, there is no attempt to assert the sovereign authority of the state which imposed the taxes within the territory of another. It's also consistent with the authority. Furthermore, there can be no justification for extending this exclusionary rule beyond what is required by its rationale. So, my lords, in that case, there was no claim, either directly or indirectly, to recover tax which is due, and the same is due in the present case. And as Lord Lloyd-Jones made it clear, there is no justification for extending the exclusionary rule beyond what is required by its rationale. Servis-Terminal is enforcing a remedy for a wrong done to it as an individual. It is not an action on behalf of a government. It is not an exercise of foreign sovereignty. It's certainly not of any type that makes the judgment unenforceable. The only sovereign act was the fact that the Russian courts gave the judgment in this case. And the Court of Appeal should not, in our submission, have proceeded on the analogy between the claim of a foreign judgment creditor remedying an individual and claims caught by the revenue rule, which is an attempt to assert the sovereign authority of the state which imposed the powers. Having considered the revenue rule, it is convenient, if I may, to turn to the related question of whether a judgment of a foreign court is itself an exercise of sovereign power of the type which gives rise to unenforceable debt obligations. That is ground 3 of our grounds. And if I could start with two passages, one from Lord Justice Newey and one from Lord Justice Snowden, as he then was. The first is at page 143. In paragraph 141, Lord Justice Newey says this: the principle that a foreign judgment has no direct operation in England reflects the common law's aversion to enforcing a foreign exercise of sovereign power, which, my lords, I think that answers Lord Briggs' point that he put to me earlier. As Professor Briggs has explained, if a foreign adjudication and judgment is understood as being an act of state sovereignty, it is regarded as completely effective within the territory of the sovereign and is completely unenforceable outside it. That logic suggests that any use of an unrecognised and unregistered judgment as a sword, including presentation of a bankruptcy petition founded on it, is objectionable. So your Lordship see the reasoning. And similarly, in paragraph 62, in Lord Justice Snowden's judgment, where he says, however...
Age.
Oh, I'm sorry, 149. Apologies. However, that judgment and order is the result of the exercise of sovereign power by the judicial organs of the Russian state. And as Lord Justice Newey has explained, the fundamental principles of state sovereignty mean that a judgment or order resulting from such exercise of foreign sovereign power has no direct effect in England and cannot be enforced for the individual benefit of the successful litigant using any of the processes of the English court.
That means processes of execution, does it? I mean, isn't that the point? You can't execute,
You can't execute without an English judgment, certainly, and that's, as I said in my core propositions, that might be one of the reasons why you want an English judgment.
And this all rolls into the related question whether bankruptcy petition is a form of execution.
Yes, well, and nobody is arguing that, and
Well,
of course,
I think your opponent
not
is.
execution.
Well,
But anyway, I'll come
I
on
think
to
your
that,
opponent is
because
arguing.
when I turn to CPD 70, I will make the very simple point that bankruptcy is not referred to as a form of execution, and as your Lordship knows, what bankruptcy is it's a form of collective enforcement, but it's not execution, and you don't need a judgment for that purpose. So the point I was about to make is that those statements conflate two different things. First of all, the exercise of sovereign power, represented by judicial adjudication, and secondly, whether the rights resulting from the adjudication are an exercise or enforcement of a sovereign right. And that's what it's conflating. And if I could just take your Lordships back briefly to the Danish case, Scatter, which you will have 1154. I just wanted to... I just wanted to take your Lordships to 1179, paragraph 58, where Lord Lloyd-Jones says, in the present case, the appellants are undoubtedly able to point to prior exercises of sovereign power by Denmark in creating its laws relating to the taxation of dividends and operating the tax system. This, however, merely provides the context for the present claims. The substance of the claims, as we have seen, does not involve any act of a sovereign character, any exercise or enforcement of a sovereign right, or any vindication of sovereign power. On the contrary, the respondent is simply bringing restitutionary claims to recover monies of which it has been defrauded, course open to any private citizen who had been similarly defrauded. And what Lord Lloyd-Jones is doing there is distinguishing between context and substance. The exercise of the sovereign power provided the context for the claims, but that did not determine the substance of those claims, which did not involve any act of sovereign power. As to the substance, the respondent was bringing restitutionary claims to recover tax refunds wrongly paid, which was a course open to any private citizen recovering payments wrongly paid. Pardon me. By analogy, in the present case, Servis-Terminal's claim is of the sort that any private company may bring against its directors for breach of duty. In substance, that claim has nothing to do with any exercise or enforcement of a sovereign right.
Just above that, you quote Dr. Mann saying the true question is whether in substance the claim asserts a public right.
Yes. Thank you, my lord. Which brings me to the sword and shield point. Whilst the Court of Appeal acknowledged that an unrecognised judgment may be determinative for some purposes, it assumed a dichotomy between the use of a judgment as a sword, which it considered to be objectionable, and other merely defensive uses that are not objectionable.
Sorry, where are you reading from?
Oh, sorry, my lord, this is my submission.
Sorry, yeah.
Pardon? Oh, I see. Paragraph 41 of the Court of Appeal's judgment is where you will find that. I wasn't intending to take your lordships to it. Yes, thank you.
Or we've just been there.
Yeah, you had, in fact...
You'd already taken us there. You'd already taken us.
I'd already taken it. Well, that will be why my notes said don't go there. The joys of advocacy. The Court of Appeal took no account of the instances in which the English courts recognise and give due effect in England to the foreign exercise of sovereign power. And the revenue and penal rules are exceptional and involve a state or its agent acting in a sovereign capacity. The proposition, the Court of Appeal extrapolated a proposition derived from those rules and treated it as a general rule, applying to anything founded in the exercise of state power, or where the context might be an exercise of state power. And in this case, one has got a judgment given by a Russian court. One can see that there is an exercise of state power, but that's context rather than substance. So, in our submission, adjudication of private rights is not an exercise of sovereign power of the type that results in adjudications being unenforceable. And we give your lordships examples in our case, in 64 to 68 of our case, and I'm not going to go through it, of exercises of foreign power that are unexceptional. So the making of laws, legal personhood, giving effect to foreign court orders, those are all, on one view, exercises of sovereign power, but we do give effect to them. A foreign judgment for a debt, a definite sum that is final, doesn't fall within the revenue or penal rules or any general exclusionary rule that is based on excesses of sovereign power. I'm not sure if I want to know that last part. I don't think it's necessary. Can I then move on to the confusion between debt and remedy? So turning to debt and remedy. A debt claim should not be conflated with the remedy for a debt, for the debt claim. And if I could start again with the Court of Appeal in paragraph 55.
55, did you say?
148.
Yeah.
And the part I wanted to pick up is near the bottom, 5 or 6 lines up from the bottom, where it says a sum for the payment of which a foreign judgment provides is not, as it appears to be, regarded as payable if the judgment is unenforceable, unless and until recognised by a court in this jurisdiction. So the starting point was that the debt resulting from the foreign judgment is unenforceable. You've got our submissions on that. But it then elides the obligation to pay the debt with the remedy to enforce the debt. The judgment debtor's obligation arises once the foreign court has made its order, and your lordships have seen the cases, the authorities that support that. The content of the obligation to pay does not change depending on the location of the debtor. What changes with the debtor's location is the process and nature of the remedy to enforce the debt. And my lords, in paragraphs 51 and 52 of our case, we refer your lordships to Della Viga and Viana for the well-known propositions that, first of all, the debt is governed by the lex causae, while the remedy is governed by the lex fori. I would like to take your lordships to the decision in McGreevy, which your lordships will find at 1065. Okay. So this decision is at 1065, and my lords, in McGreevy, the issue was whether unpaid rates constituted a petitionable debt under section 41B of the Bankruptcy Act of 1914, which denied a creditor the entitlement to present a petition unless its debt is a liquidated sum payable either immediately or at some certain future. And the debtors argued that because unpaid rates could not be recovered by an ordinary action, there could be no debt within the meaning of section 41B of the 1914 Act. Can I just interject, just to explain to your lordships, that presenting a bankruptcy petition did not require a judgment. A judgment was required under the Bankruptcy Act in order to serve a bankruptcy notice, which was one of the potential acts of bankruptcy. And in the old days, the way it went was that you would have an act of bankruptcy and you would then petition. For the purposes of petitioning, so there could be other acts of bankruptcy, for the purpose of petitioning, you did not need a judgment. So if your lordships look at the head note, you'll see that what was held was an unpaid demand rate is a debt within the meaning of section 4 subsection 1 of the Bankruptcy Act 1914, although it is not enforceable by action at law. A local authority may accordingly petition in bankruptcy in respect of such a demand. So an unpaid demand for rates was a debt for the purposes of petitioning in bankruptcy. It was not enforceable by action at law, so the local authority could petition. If I could start by taking your lordships to page 273, which is 1069 in your lordship's bundle. And as your lordship see, it's a decision of the Court of Appeal. This is Lord Justice Somerville. The main argument was based on the fact that unpaid rates cannot be recovered by an ordinary action. It was submitted, therefore, that there was no debt within section 4 subsection 1B of the Bankruptcy Act. It is common ground that unpaid rates are not recoverable by action, but it is necessary at the outset to refer to the statutes with regard to rates and their recovery. And then picking it up at internal 275, which is 1071, if I can pick it up in the middle of the page where it said, we will now consider the wording of section 4 and the sections which preceded. Section 1, which sets out what constitute acts of bankruptcy, provides as follows in subparagraph F. If he, that is the debtor, files in the court a declaration of his inability to pay his debt or presents a bankruptcy petition against himself, it seems to us plain that unpaid rates must be a debt to be taken into account when a debtor is considering whether he is in a position to file a declaration within the opening words of this subparagraph. And then, if I can go down a few lines, when one comes to section 4, which has already been read, its wording, we think, tends to negative the view that debt is used in its pleading or procedural sense. If it were, it would be unnecessary to provide that the debt must be a liquidated sum. So a debt is still a debt, regardless whether the remedy of suing by an action is available. And at the bottom of 275, whether or not debts extends in section 1 to all provable debts, we find no grounds in the Act for construing the word debt in section 4 as referring only to debts in the pleading or procedural sense, considering the words in section 4 having regard to the use of the word debts in sections 30, 33 and 1 subsection A. We would come to the conclusion that the council are a creditor and the unpaid rates is a debt within section 4. And then further down on page 1072, internal 276, although in certain contexts the word debt means a liquidated sum which can be sued for, to treat the word as prima facie so restricted is, we think, to confuse Chief Justice Dallas said, as Dallas CJ said, the debt with remedy. So what your lordships get from this is that there are contexts in which the debt might need to have certain characteristics. For example, it may need to be a liquidated sum, it may need to be immediately payable or payable at a certain future time. We see that from section 267. But those requirements do not change what a debt is. In re McGreevy, the rates were recoverable by distress. It was held that in order to be petitionable, the debt need not be actionable. The nature of the remedy for the debt, in other words, being able to plead a case or having the right to distress, to levy distress, did not determine whether the debt existed. And what Lord Justice Somerville warned against was confusing debt with remedy. Now, the issue whether a debt could be actionable does not arise in the present case because a debt for a debt or definite amount ordered to be paid by a foreign court, as your lordships have seen, is actionable. If one then goes to what the Court of Appeal said about McGreevy, I was going to take your lordships to paragraph 52, which is at page 147. And the starting point, as your lordship see, the Court of Appeal dismissed McGreevy as not being relevant because it was not concerned with an unrecognised foreign judgment. And they considered that because the local authority had the remedy of distress, if you look at the last 4 lines, there was thus no question of the individual against whom the bankruptcy petition had been brought in McGreevy not being liable for the rates in the eyes of English law. In other words, there was a remedy of distress, therefore it was a debt, therefore it was petitionable, nor of the local authority not being entitled to enforce the liability. What is important is that the Court of Appeal in McGreevy held that the rates were a debt, and that was regardless of whatever remedy they had. The debt did not cease to be a debt because the council could not bring an action, which is what they were debating. It was, as your lordship has seen, a debt recoverable by distress. An unrecognised foreign judgment also gives rise to an obligation to pay the sum due. It is a sum for which an action can be brought. Your lordships have seen that. Unlike rates, a foreign judgment debt can be enforced and recoverable by action. In order to enforce the foreign judgment by claim, it needs to have the characteristics that your lordships have seen in 46.1. In order to petition for bankruptcy, The debt has to have the characteristics in 267 of the Insolvency Act. In the present case, the debt has those characteristics. The absence of a right to direct execution of the foreign judgment does not mean there is no underlying obligation, which brings me to ground 4. Pardon me. The Court of Appeal conflated or obscured the distinction between execution of the judgment and enforcement by claim. Enforcement of a debt or definite sum determined by a final judgment is not execution of that judgment. The debt can be enforced by claim or counterclaim. That is not execution of the judgment, which would require either common law recognition or registration of the judgment. The Court of Appeal described an unimpeachable foreign money judgment being the basis of a statutory demand or bankruptcy petition as either direct operation, direct enforcement, direct effect. And how many of these are there? There are in fact 5 passages in the Court of Appeal's judgment I just wanted to take your lordships to, so if you could perhaps keep the judgment open. Starting with paragraph 39, which is on page 143. That refers to Dicey Rule 45, that a foreign judgment has no direct operation, and then says, while therefore a creditor who presents a bankruptcy or winding up petition in respect of a judgment debt may not be engaged in direct execution, it is still seeking enforcement. And then on paragraph 41, page 143, again referring to the Rule 45, no direct operation, goes, as they say, any use of an unrecognised and unregistered judgment as a sword, including presentation of a bankruptcy petition founded on it, is objectionable. Paragraph 43, which is on page 144, where it says, an unrecognised foreign judgment which has no direct operation because it arises from an exercise of a sovereign power is likewise not to be seen giving rise to a debt capable of founding bankruptcy proceedings. Paragraph 55, which is on page 148. How far down? Second sentence. While an unrecognised judgment may be determinative for certain purposes, it will have no direct operation in this jurisdiction, cannot be used as a sword, whether as regards direct execution or the basis of a bankruptcy petition. And finally, 62, which your lordships have seen in Lord Justice Snowden's judgment, a judgment or order resulting from such exercise of foreign sovereign powers no direct effect.
Can I just check the quotes of no direct operation? Is that from Dicey Rule 45? Is that what's
Yes.
being quoted there?
Yes.
Could we have the page reference for Dicey 45?
Yes. Sorry. Yep, that's going to be handled.
1378.
Thank you very much.
Thank you. Those descriptions are not apt for enforcement, counterclaim, or bankruptcy. There are a number of flaws in the argument that we identify in our written case. First of all, the Court of Appeal did not consider how a money judgment of an English court would be directly enforced in England. And that's the point, my lord, that you were raising earlier. The methods of such enforcement are found in the Civil Procedure Rules, CPR 70, and the Practice Direction, which set out methods of enforcing judgment or orders for the payment of money. And the list identifies a writ or warrant of control, a third-party debt order, a charging order, stop order or stop notice, and the county court and attachment of earnings order, or the appointment of a receiver.
And sorry, could we have the bundle reference for CPR 70?
Look, if you don't have it to hand, don't worry.
491, my lord.
491. Okay, thank you.
And my lords, what your lordships will see is the bringing of a bankruptcy or other insolvency petition is not listed. These methods all amount to execution of an English judgment, which is distinguished from enforcement. And it is, of course, only English judgments that can be executed. Foreign judgments can be enforced. When a creditor brings bankruptcy proceedings based on an unrecognised foreign judgment, it does not seek execution of the foreign judgment, but instead enforcement of the obligation to pay the judgment debt by way of an English law-governed collective enforcement process. And that, the nature of that process is supported by 3 cases that we refer to in our case. I wasn't intending to take your lordships to them, but that's Lines Brothers, Bay Oil and Ridgeway Motors. The purpose of recognition proceedings is for the English court to take notice of the foreign judgment, including whether the foreign proceedings have been concluded in accordance with the rule of law. And this is summarised in UKOS. If I could take your lordships to UKOS, which is at page 1301. Yes, UKOS Capital. And if I could take you to paragraph 87, which your lordships will find on 1301, and it's between B and G.
Between, sorry?
Letters B and G. It's quite a long passage. If I could start with, if then the question is asked just below B, the acts of foreign judiciary be treated differently from other acts of state, what is the basis of difference? The answer in our judgment is that judicial acts are not acts of state for the purpose of the Act of State doctrine. The doctrine in its classic elements has never referred to judicial acts of state, it's referred to legislative or executive acts of foreign sovereign. 2 examples will suffice. And he then refers to Lord Hope and Lord Collins. And then just at D, it is not hard to understand why there should be a distinction. Sovereigns act on their own plane, they are responsible for that to their own peoples, but internationally they are responsible only in accordance with international law and internationally recognised norms. Courts, however, are always responsible for their acts, both domestically and internationally. Domestically, they're responsible up to the level of their Supreme Court. Internationally, they're responsible in the sense that their judgments are recognisable and enforceable in other nations, only to the extent that they have observed what we would call substantive or natural justice, what the United States has called due process, what internationally is more and more being referred to as the rule of law. In other words, the judicial acts of foreign state are judged by judicial standards, including international standards regarding jurisdiction, in accordance with the doctrine separate from the Act of State doctrine, even if the dictates of comity still have an important role to play. And he then quotes from Master Rolls Linley and Pemberton and Hughes, if a judgment is pronounced by a foreign court over persons within its jurisdiction in a manner with which it is competent to deal, English courts never investigate the propriety of the proceedings in the foreign court unless they offend against the English views of substantive justice. And in the case of, sorry, that was a bit of a long quote, in the case of a bankruptcy petition based on a foreign money judgment to pay an amount due, it falls to the English bankruptcy court to consider whether the foreign proceedings resulting in that judgment were conducted in accordance with English views of substantial justice. They are encapsulated by the rules by which a judgment might be impeached. And that is what the English bankruptcy court did in this case. Mr Drelle disputed the Russian judgment on rule of law grounds, ICC Judge Burton received evidence and submissions and concluded that Mr Drelle's liability was not disputed in good faith on substantial grounds. This is all that's required to satisfy the English court that the Russian judgment had been given in compliance with the rule of law. If the debt is bona fide disputed on grounds that the foreign judgment is impeachable, that issue will need to be determined in an ordinary action. And that reflects the general bankruptcy practice. If the debt is bona fide disputed on substantial grounds, there is an action to determine whether or not to resolve that dispute. But the important point, my Lord, is fundamental point, my Lord, is this. There is an enforceable obligation, just as there might be any other enforceable obligation. It is not execution of the judgment. One is enforcing an obligation, and the fact that the obligation results from the foreign judgment actually doesn't alter matters. It is enforcement. It just gives rise to the liability. It is enforcement of the liability through bankruptcy, which, as your Lordship know, is a collective English procedure that deals with a debtor's estate and liabilities. There could be an action, there could be a bankruptcy petition, but one gets that with any debts. Sorry. That brings me to the position under the 1933 Act. The Court of Appeal concluded that the effect of re-judgment matter was that a bankruptcy petition cannot be presented in respect of a foreign judgment in advance of registration. And the conclusion was that no foreign judgment creates an enforceable debt on which a bankruptcy petition can be presented. And if I could start, sorry, my lords, if we could go back to the Court of Appeal's judgment at page 147, paragraph 50. Where it says, yes, and it's really the second where it says it is re-judgment debtor. It provides authority for the proposition that a bankruptcy petition simply cannot be presented in respect of a foreign judgment in advance of registration. And he then goes on to say that that point was integral to Master Rolls Green's reasoning, and so it's binding. And then he goes on to say a bankruptcy petition cannot be presented on the strength of an unregistered foreign judgment. That is not true of debt obligations arising out of an unregistrable foreign judgment. To reach its broader conclusion, the Court of Appeal accepted Mr Drelle's submission about the effect of re-judgment debtor. And if I can just go through to page 1029, which is tab 39. So, if your lordships have it, 1029, this is re-judgment debtor. And it's important to understand the ratio of the decision in re-judgment debtor. The ratio of the decision was that a creditor holding a registered foreign judgment can serve a bankruptcy notice under Section 11G of the 1914 Act, because a registered foreign judgment is treated as if it was a final judgment of the English court. A judgment debtor concerned a bankruptcy notice under Section 11G of the 1914 Act, which was based on a debt pursuant to a registered French judgment. As I've said to your lordships, in order to present a bankruptcy notice under Section 11G, a creditor was required to have an English judgment. Failing to pay a debt following service of a bankruptcy notice was an act of bankruptcy under the 1914 Act. That meant that a foreign judgment that had been made the subject of an English judgment could be the basis of a bankruptcy notice under Section 11G of the 1914 Act. However, if the creditor fell within the 1933 Act, he would be unable to get an English judgment because he was unable to sue on the foreign judgment. The holder of a registrable foreign judgment would not be able to get an English judgment because of Section 6 of the 1933 Act. It provided that he could not sue. And if I could just show that to your lordships. Section 6 of the 1933 Act is at page 435. If your lordships have page 435, you can see Section 6, foreign judgments which can be registered not to be enforceable otherwise. And it's no proceedings for the recovery of a sum payable under a foreign judgment, being a judgment to which this part of this Act applies, other than proceedings by way of registration of the judgment, shall be entertained by any court of the United Kingdom. So breaking this down, it applied to proceedings for recovery of a sum, payable under a foreign judgment, to which the 1933 Act applies. In other words, a registrable judgment, and a registrable judgment that applies to judgments of countries with which we have reciprocal recognition arrangements, could not be the subject matter of proceedings other than proceedings by way of registration. So if a foreign judgment creditor fell within the 1933 Act, he would be unable to get an English judgment because he could not sue on the foreign debt. And the inability to obtain an English judgment is what gave rise to the issue in rear judgment creditor. By contrast, non-registrable foreign judgments are not subject to Section 6. Where an English judgment is required, an English action may be brought which results in an English judgment. And this was recognised by Master of the Rolls Green in relation to the Judgment Extensions Act of 1868 and the Administration of Justice Act of 1920. And if we can just look at page 1034, if your lordships have page 1034, which is internal 606, it's the third line down. Accordingly, just as under the Act of 1868, so under the Act of 1920, bankruptcy proceedings were still open to the holder of a judgment covered by that Act if he chose to start proceedings upon the judgment, recover judgment here, and then issue his bankruptcy notice. So with an unregistrable judgment, the foreign judgment creditor could get an English judgment and then serve a bankruptcy notice. And as I've said to your lordships, a judgment, an English judgment, was required in order to serve a bankruptcy notice. Then, if we can go to 1037, which is internal 609, if your lordships, if I can take you through this from the start, where the Master of the Rolls said, I place upon the relevant language of the Act, it is only necessary to refer to Section 1 of the Bankruptcy Act of 1914, which provides for the service of bankruptcy notices. It would perhaps have been more logical, he makes the point that he could have said this earlier in the judgment, but that's neither here nor there. It provides in Section 1G that a debtor commits an act of bankruptcy if a creditor has obtained a final judgment or final order against him for any amount, and execution thereof not having been stayed, has served upon him in England or by leave of the court elsewhere a bankruptcy notice under this Act, and so on. It has not been suggested, and indeed could not be suggested, that those words, final judgment or final order, taken by themselves, extend to anything save a judgment or order of the court within the jurisdiction. That is to say, in England, it would be a final judgment of an English court. That's the meaning of those words, is, I think, beyond doubt. The effect of the Act of 1933, as I have construed it, is to place the foreign judgment, when registered for the purposes of bankruptcy notice, in the same position as if it was a final judgment of the English court. So he refers to Section 1G, which required a final judgment or final order. He says that that has to be a judgment, he says it was beyond doubt, of the English court. And then he explains the ratio of this decision. And the ratio of this decision is that the effect of the 1933 Act, as I have construed it, is to place the foreign judgment, when registered, for the purposes of the bankruptcy notice, in the same position as if it was a final judgment of an English court. The creditor who had a registered judgment debt could therefore serve a bankruptcy notice. And the Master of the Rolls Green said that the contrary conclusion, in other words, if registration did not mean that the foreign judgment was treated as if it was an English judgment, would have meant that the holder of a foreign judgment registered under the 1933 Act would never be able to pursue bankruptcy proceedings which required an English judgment, because the judgment creditor could not bring proceedings. And he said on page 608, which is 1036, which is the previous page, he says Section 6 prohibits any such method of dealing with a foreign judgment if it is a judgment registrable under the Act. And I showed your Lordship Section 6. In other words, where the judgment is registered under the Act, the only thing that the holder of such a judgment is entitled to do is register it. And after registering it, of course, he obtains the rights which the Act expressly says should follow upon registration. But if the argument of the respondent were correct, it would produce this startling result. There would not be open for the holder of a foreign judgment registrable under the Act ever to enforce that judgment in bankruptcy, and for this reason, that he cannot sue on it. Section 6 prevents him from doing so. The only thing he could do would be to register it. So the reasoning was that a consequence of registration, which is all the registrable judgment holder could do, the consequence of registration was it is treated as if you had an English judgment, and therefore a bankruptcy notice could be served. And your Lordship should note that Section 2.2 of the 1933 Act uses the words as if the judgment had been a judgment originally given in the registering court. Further down the page, the Master of the Rolls, and it's really in the middle of the page, he refers to the fact, of course, Section 6 only applies to judgments for the recovery of a sum of money, so the registration would only apply to that. A judgment debtor was concerned with the requirements of an act of bankruptcy. It was concerned with the requirement to have an English judgment in order to serve a bankruptcy notice under Section 1. As your Lordships know, that doctrine has long since been abolished. There is now no need to have a judgment for the purposes of a statutory demand, just a debt. So the Court of Appeal should not have concluded that the decision provides authority for the proposition that a bankruptcy petition simply cannot be presented in respect of a foreign judgment in advance of registration. Of course, that only applies to registrable judgments, and we are dealing with an unregistrable judgment, if I can put it that way. And it is the consequences, as your Lordships have seen, with Section 6 of the 1933 Act, which provides that the only proceedings, registration, and a bankruptcy petition is a proceeding. And in the context, no, you've got that point. My Lords, in paragraphs 95 to 97,
sorry, just to make sure I've understood.
Yes.
Presumably the purpose of registration is to make it easier to enforce a foreign judgment.
That's the very point I'm just going to get
Oh,
on to. Your Lordship's absolutely right. There are two different systems, and the consequences will be different in each case. But if I can come on to that after I
Yes, of course.
just made this point, which is we say in 95 to 97 why, if we're wrong, a rear judgment debtor is to the effect that Section 6 prevents the holder of every unregistered or even every unregistered foreign judgment presenting a bankruptcy petition, whether registrable or not, it was wrongly decided. But it doesn't say that. And so I do not intend to develop that further.
Just so I understand where we're going.
Yeah.
This particular judgment in this case is not, I think, a judgment to which this part of the Act applies within the meaning of Section 6, is it? Because I assume Russia isn't one of the contracting states.
My Lord, you're absolutely right. No.
But if it had been, would it still mean that, regardless of the fact we're now proceeding for bankruptcy under the Insolvency Act rather than the old Bankruptcy Act, they would be proceedings for the recovery of a sum paid under a foreign judgment?
Yes, they would be. And that's precisely the point I was about to come on to when one's assessing, is this a question of benefits or one's better than the other? But yes, if it was a registrable judgment, you would have to register it
before you could bring a bankruptcy petition.
Because a bankruptcy petition is a proceeding. And can I...
But that still makes somebody with a judgment that is unregistrable in a better place than somebody with a registrable judgment that he hasn't yet registered.
No, that's the point I'm actually going to come on to, and I really should stop promising and get on with it.
Okay.
But describing one as better than the other assumes that registration puts the holder of a registrable judgment in a worse position. What we've got is two different systems. In the case of a registrable foreign judgment, it needs to be registered before proceedings may be brought on it, but once registered, it is treated as if it is an English judgment. The judgment debtor may apply to set aside registration if the foreign judgment is impeachable. That is the point at which that question would be considered. After that, the question whether the debt is bona fide disputed because the judgment is impeachable can no longer be raised. And of course, one can execute on a registered judgment. In that sense, the creditor with a registrable judgment has an advantage on registration. In the case of an unregistrable foreign judgment for a debt or definite sum that is final, the creditor may petition. The underlying debt obligation is enforceable by claim, as your lordships have seen. The question whether the judgment is bona fide disputed because it is impeachable can be taken by the debtor, as happened in this case, and is dealt with then in the context of the bankruptcy petition. And if there is a bona fide dispute, that would be the end of it. So it's different systems, my lord. It's not one is better than the other. In a sense, there is an advantage. If you can register your judgment, if there's no challenge, it's treated as if it is an English judgment.
Can you show us the provision in the 1933 Act that has that effect?
Yes, of course. Sorry. And that was the ratio in rear judgment debtor. So where's
429 is where it's...
Sorry? No, I don't. Yeah. What was it? Give me this. 428, 429. Okay. Let's see. Sorry, I do apologise. The 1933 Act starts on 429, and Your Lordship is asking about section 2, which your Lordship will see on 431. And for section 2, subsection 2 provides, subject to provisions of this Act, with respect to the setting aside of registration, which is the process that I just described to your Lordship, a registered judgment shall, for purposes of execution, be of the same force and effect, and proceedings may be taken on a registered judgment, and then picking up the last few words, as if the judgment had been a judgment originally given in the registering court and on the date of registration.
And what are the provisions with respect to the setting aside of registration? And how does it work? That makes it sound as though you register first as an almost administrative act, but then someone can object to your registration, and that's where the teachability is.
Of course, that assumes an objection. But if an objection is taken, then they lodge an objection, and that is then dealt with.
And under what provision of the Act does that happen?
Sorry?
What's the CPR?
It's under the CPR and your
No,
Lordship.
I'm hearing section 4, and that looks right on page 433.
I haven't got section 4.
It's on page 433.
Yeah. Oh, okay, I haven't got it.
There's a gap.
Yes. Yeah, that's it, my Lord.
And it's really grounds 4 and 5 that would correspond with the
Yes.
objections that might be taken to a presentation of a petition based upon an unregisterable judgment.
Absolutely.
Yep.
And I suppose the jurisdiction point has to be a competent court,
Well,
which
yes.
is ground 2.
Yes, I mean, my Lords, the basis on which a foreign judgment debtor could object are the same. And, my Lords, what one's got is that, and your Lordships have seen what was said about the ability under the 1920 Act to continue to bring a judgment. So it's only because of Section 6, if it's registrable, one can't. And what one has got is one's got a registration system which was enacted in order to deal with those countries where we have reciprocal recognition arrangements. It has provided this process. It is a different process. One can see that if there is no objection, it's very straightforward in that you register and then it's as if you've got an English judgment, and that's the end of it. One can also see that there could be an objection. It's on the grounds on which the foreign judgment is impeachable. The difference with an unregistered judgment is simply that is that you don't have the advantages that come from registration, which is that you've got a judgment that's treated as if it's an English judgment. You can present a bankruptcy petition because Section 6 doesn't apply. You have got a debt for the reasons that I've explained to your Lordships. And if there is to be a dispute about the validity of the judgment, it will be dealt with in that context. And of course, in the bankruptcy context, the question is there a bona fide dispute as to whether or not the judgment is impeachable? The bankruptcy court, if there's a bona fide dispute, will then send it off to be dealt with by way of action.
And proceedings under Section 2, subsection 2b, include bankruptcy proceedings, yes?
Yes, my Lord, and that was...
And why, if bankrupt proceedings are not for execution as opposed to merely enforcement, why include bankruptcy proceedings if it's not a method of execution?
Well, it's a proceeding, but it's not a method of execution, my Lord. And you go back to what is execution. Execution is taking the steps that we know on the judgment. Now, if you've got a registrable judgment, then, and you register it, you can execute on it as if it's an English judgment. And you can do that, and you can take all of the steps that we know by way of execution. I hope that answers your Lordship's question. It's always worrying.
There is this potential disadvantage if your judgment is registrable but unregistered, isn't it? Which is a sort of timing disadvantage. That the time at which you can present a bankruptcy petition is often quite important because it has certain consequences in terms of disabling the debtor from doing things with his property.
Quite.
If it's a registrable judgment, then you can't present a bankruptcy petition until any issue about the impeachability of the judgment has been sorted out under Section 4.
Correct.
Conversely, if it's an unregistrable judgment, so not affected by Section 6, then you can present your bankruptcy petition and then leave the question whether it should be set aside to be dealt with in the bankruptcy proceedings on the bona fide dispute basis, but you've still, if they lose on that, got your earlier presentation date.
Well, my Lord, yes, but in both cases there's got to be substance to the impeachability point. I take your Lordship's
quite accept
point.
that. But assume that there's no substance to the impeachability point.
Well, then
the poor old creditor is worse off if his judgment is registrable than if it's not, isn't it? Because he has to wait until that has been adjudicated upon by the court under Section 4 before he can present his bankruptcy petition.
That's true, but how long the court takes in dealing with that?
Well, okay.
You know,
but I'm just looking to see if there are any cracks in the proposition that the chap with the registrable but unregistered judgment is no worse off.
Well, it doesn't matter. My proposition is they're different. And
oh yes,
they're just different systems.
Yes.
And it may well be, my Lord, that one can.
Maybe pros and cons under each.
Yeah, there are pros and cons.
There may be swings and roundabouts, but I'm just looking to see whether there are.
No, I completely understand. And what I'm trying to articulate is that there are differences, and that's what rear judgment was all about. But what you can't do, which the Court of Appeal did with respect to, you can't look at rear judgment and say that because a registrable judgment is dealt with in a particular way, you've got to read that back over into unregistrable judgments. It's just different. And the one statutory system was introduced where there are reciprocal arrangements, but not in relation to unregistrable, which, as I've said, is a point that was expressly recognised in the re-judgment debtor case. And with respect to the Court of Appeal, they've just put too much weight on this point. You can't read over and say, well, there would be a disadvantage to unrecognised judgment, to recognise judgment holders, which is a questionable proposition, but never mind. You can't read something over from that and say, therefore, I'm going to do something different with the system for unregistrable judgments. They are just different. And my overarching submission is to the extent that registrable and unregistrable judgments are treated differently, it is because unrecognised and unregistered judgments fall into different systems.
Yes.
And that's the point in relation to rear judgment debtor. Now, my Lords, I have gone more quickly than I anticipated.
Excellent.
Thank you. I was going to hand over at this point to Dr. Mokal, who's going to deal with the CBIR. I'm absolutely in your Lordship's hands as to whether you want to press straight on or whether you want to rise early and for us to...
I think press straight on.
Thank you. Do you want to move? Would your Lordship?
Yeah, well, in fact, the main thing for us is that you've got the microphones in front of you, so you don't need to adjust your position, Dr. McCall. If you're happy speaking there, I think we've got the microphones on you.
I'm happy, and I believe, my lord, that the microphones pick up from here as well as from there.
Yeah, that's fine. Thank you very much.
My lords, I'm going to deal with ground 2, which concerns Article 13 of the UNCITRAL model law, which is implemented in domestic law by the cross-border insolvency regulations, the CBIRs. Our overarching case is that ST is a foreign creditor for the purposes of Article 13. It therefore falls under the protection of Article 13, which precludes discrimination in the commencement of an English insolvency proceeding and in participation in such proceedings, just because a claim held by the creditor arises by the exercise of foreign sovereign authority. In our case, that is the very discrimination sought to be precluded by Article 13, and this is inconsistent with the Court of Appeal's reasoning and conclusion.
Yes.
Let me take my lords straight to Article 13. If I could ask you to turn to page 463. Let me start by looking at para 1, which goes, subject to paragraph 2 of this article, foreign creditors have the same rights regarding the commencement of and participation in a proceeding under British insolvency law as creditors in Great Britain. My lords, it's common ground that this is a non-discrimination provision. Like any non-discrimination provision, it requires identification of two groups. The group that is sought to be protected from discrimination, and the comparator group, whose position is to serve as the baseline. Here, the protected group is foreign creditors. The comparator group is creditors in Great Britain. Both these terms, foreign creditors and creditors in Great Britain, are terms of art in the context of the model law. I will take your lordships to the explanations for these terms as the model law uses them. Now, the target of Article 13 is solely discrimination on the grounds of foreignness. Para 1 of Article 13 does not affect any objection to a foreign creditor being able to commence an insolvency proceeding here or be able to participate in such proceeding. That does not relate to the creditor's foreignness in the relevant sense. For that reason, Para 1 does not affect the objection that the creditor holds a claim pursuant to the judgment of a court that lacked jurisdiction. This is for the simple reason that if the creditor is a creditor by virtue of holding the benefit of a judgment in its favor, and the judgment has been given by a foreign court, the foreignness of the court does not play a part in the question whether the court has competence to give the judgment. We can see that from the fact that a foreign court that has given the judgment may have jurisdiction, or alternatively, it may not. The foreignness drops out. It's the factors going to its having jurisdiction which matter.
And presumably you'd say the same in relation to grounds of impeachability of the judgment, is that right?
I do, my lord, yes. The point there is that para 1, as my lords have seen, gives the foreign creditor the same rights to commence. The intention is not to give the foreign creditor a preferential position. Therefore, all of the requirements that a creditor in Great Britain must meet in order to be entitled to commence proceedings, a foreign creditor must meet, and all of the defenses which may be raised against a creditor in Great Britain may equally be raised against a foreign creditor. That's the same rights.
So, I mean, just coming towards the facts of this case as an example, if the appellant had been an English creditor under the Russian judgment, it wouldn't thereby be relieved or entitled to complain about discrimination in relation to objections taken to the foreignness of the judgment.
If I understand my lord's point, the point is that if ST were a company incorporated or based in England, yes, in those circumstances, as I will explain to your lordships, the English creditor would qualify for the benefit of the anti-discrimination provision. This is what my argument builds up to, but the essence of the submission is the following. Foreign creditor, the foreignness of the creditor may be determined in a variety of ways. For the purposes of Article 13, the core way, not the only, but the core way in which the creditor can qualify as a foreign creditor for the purposes of para 1 is that the creditor holds a judgment arising under foreign applicable law. So, in response to your lordship's question, if it's an English creditor holding the same judgment, would the English creditor fall under the protection of Article 13? My response is yes, it would. That, as I said, is what my argument builds up to in what my lords by the end might think is painstaking detail. If I may proceed. Just to make the point, because this is a non-discrimination provision, if a foreign creditor seeks to commence insolvency proceedings here, the court is not prevented from considering under ordinary insolvency law principles whether there is a genuine and substantial dispute, and such a dispute may arise because of the matters which make the foreign money judgment impeachable.
You referred to the definition of foreign creditors. Can you just tell us where we find that?
I will. That is a substantial part of my argument.
All right, but can you just tell me which article it is?
The term foreign creditor itself is not defined.
Okay.
The term creditor is not defined. And so we have to look at how those words appear in the context of the model law, keeping in mind that the model law is an international instrument, not an English law instrument, and we have to read it in that way, and that is how we have hope of discerning the meaning of this term foreign creditor. As I said at the outset,
if there's not a short provision and you're going to develop it, let's proceed in that way.
I'm grateful. My Lords, the key point is this in laying the groundwork for how to understand this notion of foreign creditor. Foreign creditors are referred to by reference to the claims that they hold. And we get that from paras 2 and 3. It is the holding of a claim addressed by paras 2 and 3 which makes a person a foreign creditor. So turning to para 2, this deals with the ranking of claims. It is in two parts. First, it says para 1 does not affect the ranking of claims in relevantly an English insolvency proceeding. Second, it prohibits a claim being ranked lower than general unsecured claims solely because the holder of such a claim is a foreign creditor. This echoes the point I made a couple of minutes back. The discrimination which is sought to be precluded is discrimination solely on the grounds of the foreignness of the creditor understood properly. The point I will develop is this. In insolvency proceedings, claims are ranked by their legal character, by whether they are secured or unsecured, whether they are given a statutory preference, whether they are deferred by statute, and so on. Claims are not ranked by the address of their holder. And there is nothing in para 2 to suggest otherwise. To the contrary, para 2 sets the floor for the ranking of a foreign creditor by the character of the claim on par with general unsecured claims. The same focus on the legal character of the claim is even clearer in para 3. The role of para 3 is to permit one category of claim owed to a foreign state, qua sovereign, to benefit from the protections of paras 1 and 2. The chapeau to para 3 says, a claim may not be challenged solely on the grounds that it is a claim by a foreign tax or social security authority. Plainly, my lords, such a claim is protected by reference to its legal character. What is protected is the sort of claim brought by a foreign tax or social security authority, that is, a foreign law tax or social security claim. Subpara A of para 3 preserves challenge on the ground that the claim is a penalty. Subpara B preserves challenge on any other ground on which a claim might be rejected in an insolvency proceeding.
Then I'm somewhat puzzled as to how paragraph 3 works. There's the revenue rule and the penalty rule. So
Yes.
it expressly preserves the penalty rule.
It does.
And if under English and British insolvency law, a liquidator or a trustee in bankruptcy could refuse to admit a claim to proof on the basis that it was a foreign revenue claim, why isn't that preserved by B? In which case, what effect does subparagraph 3 really have?
Because B is the more general provision which is subject to the reversal in the chapeau to para 3 of the revenue rule.
Yeah.
And, my lords, in relation to...
In other words, it would have to be some aspect of British insolvency law otherwise than the one struck down by the first words of paragraph 3.
Yes.
Yeah, okay.
In relation to insolvency commencement and participation, Article 13 does reverse the revenue rule. This is common ground,
Yes.
and it was noted by Lord Justice Snowden,
Yeah.
as he then was. If I could ask you to go to page 153. And look at para 70 of His Lordship's judgment. The reasoning is important. Quote, for completeness, I should add that
Sorry, where are you?
Para 70, my lord, at page
70, yes, thank
70.
you. Yeah.
For completeness, I should add that the specific treatment of foreign revenue claims, which was an issue in Government of India and Taylor, has been reversed by statute. Article 13(3) now provides that in English insolvency proceedings, a claim may not be challenged solely on the grounds that it is a claim by a foreign tax or social security authority. But then his lordship continues, but that provision does not affect the general approach to foreign judgments that I have outlined above. Close quote. But that general approach focuses on foreign sovereignty. And the argument that I will develop is this. Article 13 precludes discrimination in relation to commencement and participation in English insolvency proceedings just because a claim arises by the exercise of foreign sovereignty. Now, to be clear, Article 13 does not convert a foreign claim into an English claim. And it certainly does not convert a foreign judgment into an English judgment. What Article 13 does do is remove one basis for discrimination and one basis alone, the basis that the claim is foreign in legal character.
The claim.
Well, that's just overview of my submissions, and I will develop this argument and the route that I propose to take. Maybe I should, maybe this would be a convenient time to...
I mean, do you want to tell us the route, and then that might be...
Certainly. I have 5 propositions, my lord. First, I will spend a couple of minutes on how the model law as an international instrument falls to be interpreted. This is important in relation to several points which have been taken by Mr. Drelle today. Second, I'll look at the original text of Article 13, which, as we will see, is an aid to interpretation of its British counterpart.
I missed the first part of that. Sorry, what was that?
My apologies, my lord.
Don't.
I'll address the interpretive principles which apply when we read the CBIR. Then the second point is the original text of Article 13, which is very important in my submission. Third, those 2 terms of art which I've already highlighted and which already cause my lords some concern, the concepts of foreign and in Great Britain. Fourth, I look at the meaning of the term creditor as it appears in Article 13. And fifth and finally, I will spend some time on Article 14, which also deals with the position of certain foreign creditors. Those are the 5 issues that I propose to address this afternoon.
Thank you. So it sounds as though that is a convenient moment. We'll adjourn there and resume at 2 o'clock, please.